Regulatory and economic laws form the essential, often unseen architecture of the modern Indian economy. They're not merely abstract rules confined to legal textbooks, rather, they're the very scaffolding that supports every stage of the business lifecycle. These laws meticulously govern how an enterprise is conceived, how it secures financing, the manner in which it operates day to day, and the systems of supervision that monitor its health. They also provide frameworks for its rescue when it falters, or for imposing sanctions when it deviates from its legal obligations. This chapter follows a simple idea. Every significant business decision touches one or more of four pillars: authorization, disclosure, money flows, and enforcement. By learning to view business challenges through this four-part lens, managers can develop a structured and predictable way to identify legal touchpoints, assess potential risks, and formulate compliance strategies. This approach moves legal understanding from a reactive, problem-solving function to a proactive, decision-shaping tool. To truly master the regulatory environment, a manager must understand not just the individual pillars, but how the key statutes fit together to form a cohesive, albeit complex, system. For instance, the Industries, Development and Regulation Act, 1951, still sets the foundational template for union government oversight over strategic industries. The Prevention of Money Laundering Act, or PMLA, ensures that the financial system does not legitimize criminal proceeds. It is the discipline behind KYC and suspicious transaction reporting. The Insolvency and Bankruptcy Code, or IBC, provides a time-bound route to rescue viable businesses and liquidate unviable ones, placing creditors in control. FEMA is the grammar of cross-border money, distinguishing current from capital transactions and setting the rules for FDI, ODI, and remittances. Offshore, POEM, GAR, and BEPS 2.0 explain how global structuring interacts with Indian tax and exchange control, privileging real substance over paper form. SEBI's framework governs market integrity, insider trading, takeovers, public issues, and fair dealing. And the Fugitive Economic Offenders Act deters flight from jurisdiction in large economic offenses by enabling attachment and confiscation. To transform legal knowledge from passive information into an active decision-making tool, managers need a practical compass. This compass consists of 7 essential questions. Are we authorized to do this activity at this scale in this sector? Who must we tell, by when, and in what form? Where does the money come from and go to? And do pricing valuation rules apply? Who is the beneficial owner behind our counterparties? If things go wrong, what process applies? What are the personal exposures of directors and officers? And what records must we keep to evidence compliance and protect decisions? This chapter is structured to guide you systematically. We'll start with the IDR Act, move to PMLA's anti-money laundering controls, then dive into the IBC's insolvency process and cover FEMA, offshore structures, SEBI regulations, and the FEOA. Use the checklists and tables as quick controls. Return to the black letter sections when you need doctrinal depth. The aim is simple: operate confidently, comply predictably, and decide with clarity. Our deep dive begins with the Industries, Development and Regulation Act, 1951, or IDR Act. It's a map of India's industrial governance, what counts as an industry, what an industrial undertaking is, and what a license means. First, what is an industry? In the dictionary sense, it's organized economic activity. In a business sense, it's a manufacturing ecosystem turning inputs into outputs at scale. But in the policy sense, the IDR Act empowered the Union to declare scheduled industries, strategic sectors where the center may plan, regulate, or license capacity. An industrial undertaking is the business unit that manufactures or processes goods. Think a factory or plant, not a mere trading office. Manufacture or processing is any value-adding transformation, assembling, mixing, refining, fabricating, bottling, or printing. And it's crucial to distinguish registration, which records the existence of an undertaking, from a license, which is a prior permission to establish, expand, or change capacity in a controlled sector. So what does it mean to take a license? It's a formal yes from the competent authority. The first practical step is to know your sector controller. Second, you must scope your activity. Define products, capacities, processes, location, and utilities, ensuring they match the notified schedules. Third, gather your prerequisite NOCs. This includes clearances for land use, environment, fire safety, and building bylaws. Fourth, prepare the application dossier. This includes everything from entity KYC and technical write-ups to plant layouts and safety manuals. Fifth is evaluation and inspection. Expect scrutiny, site visits, and queries. You may be asked to resize capacity or enhance safety systems. Finally, the grant. A license always carries conditions. Breaching them can lead to suspension or revocation. Remember the mnemonic, RLC, register what you are, license what you do, comply with what you promised. Most general manufacturing is de-licensed today, yet the IDR architecture lives on. It lives on as a constitutional anchor for union oversight, a definitions layer used across policies, and as a handoff to specialized regimes that run IDR-style licensing for safety and sovereignty reasons. This means you must map the interfaces. Your industrial unit doesn't exist in isolation. It connects with the Factories Act for worker safety, environment laws for consents, BIS for quality, state policies for land, and FEMA for foreign ownership. So the manager's formation checklist is clear. Confirm your license status and identify the controller. Prepare a detailed process note. Obtain all pre-establishment clearances. Build a compliance calendar. And finally, align your contracts and insurance with your license conditions. Now we turn to the Prevention of Money Laundering Act, or PMLA. This law targets the concealment and projection of the proceeds of crime as legitimate. It imposes duties on reporting entities like banks and brokers. These duties include KYC, record keeping, ongoing monitoring, and appointing compliance officers. The state's enforcement toolkit is powerful. Attachment, adjudication, confiscation, search, seizure, and arrest. Cooperation is not optional. When a business defaults, the Insolvency and Bankruptcy Code, or IBC, provides a creditor-in-control framework. The key trigger is a default, the non-payment of a debt when it's due. Once admitted by the NCLT, a moratorium kicks in. This is a statutory stay on all suits, executions, and security enforcement against the company. The SERP arc is a time-bound process. It moves from admission to the constitution of a Committee of Creditors, or COC, who then evaluate resolution plans. If a plan is approved by 66% of the COC and the NCLT, it becomes binding. If not, the company goes into liquidation. From a manager's lens, debtors must cooperate and prepare a clean data room. Creditors must file claims on time and engage constructively. The IBC's reach extends to personal insolvency, particularly for personal guarantors to corporate debtors. Lenders can now pursue guarantors alongside the company. For cross-border insolvency, the code provides for reciprocal arrangements and letters of request to foreign courts, though a comprehensive framework is still evolving. The process is managed by licensed insolvency professionals, or IPs. They are registered with the Insolvency and Bankruptcy Board of India, IBBI. Their duties are extensive: take control of assets, verify claims, manage the COC, run a transparent process for resolution plans, and pursue avoidance actions. So, the manager's checklist is clear. As a debtor, prepare your data and continuity plan. As a creditor, file claims promptly and engage with the process. This proactive approach is key to navigating the complexities of the IBC.